All right, you are watching day 2 of After the Hearing, something that we are doing a part of a streaming show we have here on WFAA Plus. We are giving you comprehensive coverage of this track meet stabbing trial. Karmelo-Anthony is charged with murder and the death of Austin Metcalf. This is day 2 of jury selection, and breaking news, we have seated a jury in this track meet stabbing trial. We are here live on location, right in front of the Collin-County courthouse. This is as close as you can get, as you can imagine. There are a lot of limitations in terms of where you can shoot and where you can be. This is as close as we can get to this Collin-County courthouse. Now let's introduce our panel. We have Vanita Parker. Vanita, you've been on both sides of the aisle, the defense, prosecution, 30 years as a lawyer.
Yes, that's correct.
So you know how this process works.
I've seen this process many a times.
And we've got Rebecca Lopez, senior crime and justice reporter. You've covered every major trial here for the last 25 years here in North Texas.
Yeah, a lot of trials, yes, definitely.
So we're going to start with the topic that everyone has been talking about, and it happened very late in proceedings today. I think the best way to go about this is to talk through the process of how this all occurred.
Yes.
Okay, so 3 jurors were dismissed. The defense puts out an objection. Can you speak to sort of how this process works in terms of the strikes and how those jurors were dismissed?
Okay. In any felony case, the state and the defense each gets 10 strikes. So in this case, the state used their 10 strikes as well as the defense used 10 strikes. After the strikes are done, they show their strikes. The judge reads who the potential jurors are.
Yeah.
And after the potential jurors are announced, the state or the defense can object to the panel that has been seated. And in this case, Mr. Howard objected under a Batson challenge, which is where he's saying there was 3 particular jurors that were removed from the state's perspective for, they said, race reasons.
Yeah, and I'm going to give you the actual quote so that people are familiar and have some context for it.
Okay.
The actual quote is, and these are for panelists 27, 37, and 48. And the quote is, those 3 were 100% of the available African American jurors in the strike zone. And the strike zone, you're saying, is the early part of the number of panelists, right, who could be called to the jury.
Right. It would be the first 32 jurors in this case.
Okay.
Would be in the strike zone.
Okay. And the state in this situation is claiming what? That the 3 were struck because they were educators and not for race-related reasons.
Correct. The state, when the state was questioned as to why their reasoning for striking these individual jurors, they were educators involved with educating children or individuals in schools, and that's their reason.
Now, Rebecca, the families have said we don't want to make this about
Right.
race. The attorneys have said we don't want to make this case about race. And here we are talking about it's the first thing we talk about.
Well, I thought it was very interesting because today the prosecutor actually told the jury when he was asking them questions about race. He says, in my 30 years, I've never had this conversation with a jury panel. And so, that's the elephant in the room, though. And it is important to note that the questionnaires, that is the wording on the questionnaires. Do you identify as an African American and because we didn't get a chance to see the questionnaires because they were under seal and we were not allowed to get a copy of it, I don't know if it also says, are you of mixed race? So we really don't know what the makeup of this jury panel is and if there are minorities or people of color and how they identify on the panel.
Right.
We haven't been able to see them physically. We won't know that until tomorrow.
And I think a lot of people have said there are no black jurors on the jury. Is not something we know until we get in there tomorrow morning for opening statements and we see the jury for the very first time.
I would say, just based on what the challenges were done, it sounds like it, but again, we don't know if any of them have any percentage of black in them, but that they identified as white or Hispanic.
And one of the things that I thought was really telling also is that I've never seen a defense attorney do this. He went completely off topic and says, I'm going to just ask you a question, because what they're trying to drill down and what they were trying to get to is, are there any people with really serious biases, whether that's racial or how they felt about this case? Have you already prejudged this person based on age, youth, race? And he asked them, how do you feel about the current immigration policy in the United States? I went back through, because we got the numbers of the juror, like number 5, number 11. I went back through and I also wrote how they answered those questions. And I would say there were probably, and I'll go back, but the majority either were neutral or they leaned towards anti-immigration, that they didn't feel like the immigration policy was fair in this country. And they didn't have anybody that was like just really gung-ho pro-immigration that I saw based on how they answered that question. So I don't know what that says, but it clearly played into how the defense picked this jury.
If you can, Vanita, can you step into the shoes of Mike Howard for just a second?
Okay.
You lose this objection. Your thoughts?
I lose this objection, and I'm like, I go, okay, you know, we're not trying this because of race. That wasn't the reason, but I think for maybe Carmelo-Anthony and maybe their supporters thinking that they should have some African Americans on this jury, and he felt that that would be more of a jury of his peers, even though that's not necessarily the true meaning of jury of your peers, because that could mean society in general and people of Collin County and not just the same race that you are.
What would have happened had the judge ruled for the defense? Would they have brought back some of the jurors that they had released, or what would they have done in that case? Or put them back on the jury?
Yes. The mechanism at that point would be to put juror 27, 38.
47 and 48.
And they would be back, depending on if there was not a race-neutral reason. And the judge did not feel that, he would put them back in the jury panel, and they would sit on this panel.
Why would the prosecution object to educators being on this panel?
You know, I don't know. It could be that they don't want any educators because they are too close, like they would know how things work. I mean, that would be to the prosecutors. I haven't seen the evidence.
I know one juror,
one juror said something about
that they were an educator in Frisco ISD, right? And obviously that I understand the issue there.
Yeah. And it could just be that maybe it would end up being too much for those educators later on down the trial, knowing what they were going to be having to decide.
Yeah.
Mm-hmm. And it would be too hard for them, even though they didn't say that during the questioning.
And I think that's why they hit so much on age, because that was a really big deal today. They kept asking about age, and many of the jurors, some of them said, look, I put myself in those shoes, and if my son's the same age, and I can't imagine how I would react if my son was the victim. But then on the other side, others said, I cannot sentence or find somebody guilty of murder that is such a young age and put them in prison for the rest of their lives. So age was definitely also a factor in all of this.
Yeah.
I think anytime you have a young defendant, whether it's a murder charge or any kind of serious allegation, their ages. That question is going to get a lot of jurors off the panel, because they can't sit in judgment with regards to punishment, whether it be on the high end or low end.
As you can imagine, talk about the dismissal of these 3 jurors went over very quickly, and people are already starting to talk about it.
Mm-hmm.
Next Generation Action Network, which is a civic group, is questioning the, quote, fairness and integrity of this judicial process. And I'm going to read the full quote from Dominique Alexander. He's quoted saying, "We are deeply disturbed by what we witnessed during jury selection today." Rebecca, your thoughts on that?
Yeah, you know, they have often spoken out in civil rights cases, and they have been very outspoken about this case as well, and they have some deep concerns about how this jury was selected. And I'm assuming that there's probably other people out there that feel the same way. Then they hear there are no African American jurors, then are you really being judged by a jury of your peer? And that's the question that you have to ask. Is it a jury of your peers if there is no one that looks like you on the jury?
If you're Mike Howard defense attorney, and you're seeing statements from civic groups about this. Are you listening to any of that? Are you reading any of that? It's the day before opening statements.
He probably doesn't have time to sit and read what any, racial or any kind of group that's out there that's saying something. I think he's just getting ready for tomorrow and opening statements and getting ready for the evidence the state of Texas is going to be presenting tomorrow. I think he's turned off the noise. He doesn't have time for that.
Yeah. So if people are just joining us and people probably just watched the first episode, Rebecca, can you rewind us a little bit? Take us from the end of Monday into Tuesday. We go from 550 to 600 to 250. Tell us about that process.
Yeah, we went to 250, and they were eliminated basically on how they answered the questionnaire, and also did they have conflicts of interest? Did they know the judge? Do they know anybody that's involved in the case? Do they already have prejudices about? Have they already decided guilt, innocence? So a lot of those people were let go, and in fact, they let go of 100 right away, even when they came down to the 250, because those people were towards the back of the line, so to speak. But there was just a lot of drilling down with these jurors today, asking them very specific questions about their feelings and how they felt, because again, that these attorneys want to find people that are going to follow the law, and they went over that quite a bit. The law. What does the law say about self-defense? When can you use self-defense? And there was at one point an objection about that. Can you talk a little bit about that?
I think at that point the defense was getting too specific and trying to commit the jurors to a certain set of facts, and that's objectionable, and you're not allowed to do that when you pick a jury. And I think that's when Mr. Mitchell finally said, "That's enough.
Yeah.
I can let you go so far, but we've got to stop."
We're so many minutes into this show already, and we have not talked about the fact that we're seeing Carmelo-Anthony for the first time in almost a year. We're
That's
inside
correct.
the ceremonial courtroom. It is not Judge Roach's 296th, so we're watching them on a screen, and Carmelo-Anthony is sitting there. How would you describe? He's dressed in a suit and tie, and he's sitting right next to Mike Howard.
Yes, he's sitting right next to Mike Howard. I think he was wearing a blue suit with like a pink or purple shirt. It's hard to tell because the colors might be off on the screens that we were seeing. But a couple of the jurors commented on, I look at him and he looks like a little kid. This is what some of the jurors said, quote. And so, they thought that he looked obviously very young. And at one point, Mike Howard is saying something, and he says, "Carmelo, cover your ears." And I don't think he meant literally for him to cover his ears. And he went and he covered his ears. Yeah. And it has other attorneys like, "No, don't cover your ears." And I thought that was a very interesting moment at that time. And I wondered how that went with the jurors that were there.
If you can, talk to us about the strategy behind how you dress your defendant. I know you have these conversations all the time with people you defend.
Right, and so obviously Carmelo is a teenager, and he's used to not wearing a suit, and obviously you're gonna make sure you're cleaned up for trial, which you would with any defendant that's facing charges of any kind. So that haircut, make sure you're clean shaven. Have a suit on, have a tie, which Carmelo did, and he was dressed appropriately for court, and but he is young, and you can tell the way he's seated there, and I'm sure he's lost weight in anticipation of this trial and the stress of it, because it is a big deal. He's just there sitting.
Yeah, and it's important to note that he is out on bond, and typically when they are in jail, then they bring them whatever but they can also wear suits. But I have also seen defendants that come out in their uniforms, but I think there's a state law now. There's a law now that says that you can't do that. They have to be dressed up.
Right. I mean, it's prejudicial.
It's prejudicial.
Right.
And so every time there's a trial or any kind of case where maybe not a trial before the judge, but if the public's involved or jury, they will be dressed up in street clothes.
That's not unusual, yeah.
So we've seated a jury. We have 12 active jurors, and we'll have 6 alternates. Have you ever had 6 alternates in any cases that you've tried?
Not myself, but I have seen alternates in trials.
So can you explain the rationale? They don't know whether they're an alternate or an active juror in this case.
I think they would know they're an alternate because the first 12 would be the jurors. that are seated. And
Okay.
then the state and defense both had 3 additional strikes because that would just increase increase the jury panel.
Okay.
Because you go through the first 32, and that would be the 12 to sit on the panel, and then you have 10 strikes per side, so that's 32 jurors, and then you have 6 additional jurors that are sitting as alternates, and that would be that the state and defense would each get 3 additional strikes, and so there you go to additional 12. You went 12 more people
Okay.
past the strikes, the official strike zone.
So do the jurors know whether they are alternates or not?
I would assume that Judge Roach would inform them that tomorrow if
Okay.
they don't know that today. I would think they would know that by tomorrow.
So we heard from Dewey Mitchell, who represents the state, who's, would they call that second chair?
Yes,
Or-
he is. I think Bill Werski would be the first chair, and
Yeah.
Dewey would be second in this trial.
And we haven't heard from Bill, which is, we did not hear from Bill. We did hear from the lead defense attorney. We didn't
Yeah.
hear from his second chair, Toby Shook, much, other than he was passing notes and sending questions. I think at one point he saw one of the jurors nodding, and he's like, that juror just nodded to that question, it grilled that juror. And so that's what Toby was there to do. But we never heard from the actual lead prosecutor in this case, Bill.
I
Bisbee.
anticipate. Sorry.
No, go ahead, yeah.
I anticipate Bill making opening statements tomorrow, and for the same, it could be. I'm not sure if it's Mike or Toby that would be doing opening tomorrow, but I have a feeling it might be Toby doing that.
And we'll get into opening in just a second here. You know, Defense Attorney Mike Howard, right off the bat, had this statement: "I am proud to represent Karmelo-Anthony," and I want you to talk about this if you can, Rebecca. He says, "I am proud to represent Karmelo-Anthony. I'm going to refer to him as Mello," and I think you can tell us why. And his life is literally going to be in your hands, speaking to the potential jurors.
Yeah, he says his life is in your hands. And then he said, we call him Mello because that's what his coaches call him, that's what his friends call him, and that's what, his family calls him. And that is, you're humanizing the suspect. That is what, defense attorneys are paid to do. They are paid to make sure that you feel some sort of empathy, or you feel something towards the defendant, that they're not just this cold-blooded killer. You might have some opinions on that, but it's the defense's job to make sure that the jury sees him as a human, and Mello is what he is called. That's his nickname.
Correct.
We noticed a difference in strategy between the prosecution and the defense. You're saying the prosecution did a little bit of both, but the prosecution asked questions to all the jurors, whereas Mike Howard with the defense had individual questions for jurors and had them all answer in a row.
And I think there was time to how to figure out how you wanted to approach this panel this big, but I think this case is important. To the state as well as to the defense, but he needed to hear each person say that. So when he did individual voir dire for each juror, he wanted to hear them say, "Yes, I can be fair."
Yeah.
Joe, but we needed to just quickly address the fact that we just had a technical issue, and that's why we had this, quick little break. But we're back, and our audio and everything is back and working. Our light went out for just a second. But, one of the things that Mike Howard also said is my biggest fear is not getting to ask everyone the questions I need to ask them. They were limited to I think it was an hour and 40 minutes each. And you're trying to get as much information as you can. So I think that's why he focused so much on that strike zone, the potential jurors, because there were one juror, I think, in the back kind of got offended. He's like, well, why aren't we getting a chance to give our opinions?
Yeah.
Because chances are you're not going to make the jury. So he didn't want to spend a whole lot of time with the people in the back.
Right. And Dewey mentioned that initially when he started
Yeah.
voir dire, that he was not going to pay that much attention to individuals in the back.
Yes.
So let's talk about a question that popped up that got a reaction from people even inside our courtroom, and that was the immigration question.
Yeah.
Why would that pop up? And I'm trying to find the actual quote inside here, but it had to do with what is your take on immigration policy here in the U.S. And he one by one asked that question.
And he asked also about ICE, because somebody said, well, what do you mean? Well, I don't know what the immigration policy is.
Yeah.
He goes, well, how do you feel about ICE? But I can't define what the immigration policy is. You guys know, and you have to make up your own opinions.
Vanita, why would that come up here in Collin County during this trial?
I think he wanted to see with 1 to 10 where jurors sat, and we talked about it. It's with 1 being more just pro I love immigration. It's handled correctly. To 10, it's not, we're not doing the right thing.
Yeah.
And so when he got answers, I think for the defense, it was more, I don't want to be political in this sense, but more democratic. If you, the higher the number, it was more that you have more empathy, maybe for the defendant in that situation.
Let's talk about tomorrow. Tomorrow's another big day in this trial. There's no good or bad day. There's just a day in the trial. Tomorrow we have opening statements. How are you preparing? If you're Mike Howard and Bill Werski.
You are going back everything in your case. You are also seeing exactly who's on your jury, because sometimes you may want to word certain things and talk about, to kind of try to engage those certain jurors that are on your jury. But I think with regards to opening statement, it's going to be the evidence will show, and we anticipate you hearing this. And I think it's going to be just going back over, making sure they know what they're going to say and not overstep and give too much to the jury.
And now we have a better idea of the whole self-defense, because he broke down for the jury when you can claim self-defense, and he went through that very methodically with them, and then asked them, are you going to have a problem with this?
Do you think that's laying the groundwork a little bit?
Yeah, oh yeah, because, and he said, look, once you determine that one side is saying self-defense, and it is up to the prosecution to prove beyond a reasonable doubt that self-defense was not a factor. So it is not incumbent upon them to put Karmelo-Anthony on the stand, and they brought that up over and over. I think the way that they were asking the questions, I do not believe that they're going to put this teenager on the stand, or this defendant on the stand, because they kept saying, are you going to have an issue if he doesn't answer for the other side? But he doesn't have to. He has a Fifth Amendment right not to do that.
Correct.
So talk a little bit about the self-defense strategy and why it was important to break that down for the jury.
Well, I think it was important to break it down for the jury, because that is going to probably be an issue in this trial. And Mr. Howard can get that, or Toby Shook can get that information through another witness. There just has to be a scintilla of evidence. Something has to be other than, Karmelo getting on the stand and saying I did it, because that opens him up to so much more. And as long as they can get that through cross-examination, they can get that evidence in, and through one of the teenagers that witnessed this.
Or there was also in the affidavit that was written by the police, some of the first things that Karmelo-Anthony says is, he put his hands on me and I reacted. Or he also said, is what I did considered self-defense? And it's in a arrest affidavit. Would that be scintilla enough to get that self-defense in?
It could be exactly what judge needs to get in. But you're going to have testimony, because that police report or that affidavit's not going to be in evidence.
And then he talks a little bit about the different levels of how you can, the murder in Texas, because we don't have first, second, third degree murders in Texas like you hear in other places.
Right.
It is murder, manslaughter, negligent homicide, ag assault, and it goes down from there. But do you think that there will be a point that maybe they're going to try to get those lesser charges? Because right now he's just charged with murder, but they can add the lesser charges to the charge.
We heard about manslaughter.
Yes.
Right? He posed that question to the jurors.
And so there's going to be a couple of things you have to look at, because with regards to using the self-defense, it's like, I did it, but I have a reason, and you're excused from committing the act that has been done. So that's not reckless. It's intentionally, knowingly. Like, I intentionally, knowingly did it. And so, it might be something at some point, it does get thrown in there because they just want to do that. But, and sometimes that happens. It just depends on if there's the evidence that it comes forward. But otherwise, it's like, that's just a reason to be not guilty, because if the jury feels beyond a reasonable doubt that self-defense was used,
then it's enough. And then people asked about, well, what about sudden passion? But sudden passion in Texas, it cannot be used unless it is in the punishment phase. And explain what sudden passion is and why it's only used in punishment.
Well, sudden passion, you have to have, there's no time to reflect or to do anything, and it's something right then and there that happened. Whether it be, you see, the examples were that you see, your child being assaulted, or your child being something happening to someone in your family right then and there, and there's nothing you can do. You don't have time to cool off. You just do it.
And it brings the sentencing guidelines down. From 5 to 99 to 2 to 20.
2 to 20.
Yeah. There is so much to talk.
Yeah.
We could talk about this for the next 4 hours.
We could.
We don't have that time, and we're also losing sunlight. Vanita, thank you for joining us. Rebecca, thank you for joining us. We're going to have a legal expert every night as we talk about what's happened. The big news, big takeaway here is a jury is seated. We're going to have opening statements tomorrow. You are watching after the hearing. We'll have another episode of this tomorrow night with another legal expert. Thank you for watching.
Tonight, we take you inside the case that stunned North Texas. It was supposed to be an ordinary spring morning at a high school track meet in Frisco. But in a matter of seconds, a confrontation between two teenagers turned deadly. 17-year-old Austin Metcalf was stabbed at Kirkendall Stadium. Police say the suspect, 17-year-old Karmelo-Anthony, admitted to it. He was charged with murder. Anthony's attorneys argue he acted in self-defense. This case has become far more than a courtroom battle. It has divided public opinion, fueled online outrage, triggered protests, and transformed two North Texas families forever. What exactly happened under that tent at that track meet? What do witnesses say they saw? What evidence will jurors hear? And how will a Collin-County jury weigh claims of self-defense against a charge of murder? Tonight, we examine the timeline, the evidence, the legal strategy, and the emotional fallout from a tragedy that continues to reverberate across Frisco and beyond. Our Jobin Panicker has a look at how we got here.
It was a deadly confrontation under a track team tent that lasted only moments and would set off a chain of events that would dominate headlines for more than a year.
I got the alleged suspect in handcuffs right now, the chains.
April 2nd, 2025, at Kirkendall Stadium in Frisco, Austin Metcalf, a junior at Memorial High School, was stabbed and within hours pronounced dead.
Karmelo-Anthony, class of 2025.
Another student from Centennial, Karmelo-Anthony, was arrested the same day for murder.
I got a phone call from Hunter.
A day later, the Metcalf family, including Austin's twin brother, spoke with us.
Just because the kid was mad, my son is not here anymore, and I don't understand it. His brother's lost his best friend.
It's just really heartbreaking to see someone that cares for you that much and does everything, even by your side, no matter what, just pass away like that.
April 14th, Karmelo-Anthony's bond is reduced from $1 million to $250,000. He was escorted from jail and released under house arrest with an ankle monitor.
Explain your self-defense.
A case already combustible just went nuclear.
There's two sides to every story, and we've only heard one side.
We have endured death threats.
April 17th, the Anthony family speaks for the first time at a press conference. Austin's father, Jeff Metcalf, also shows up.
Is a disrespect to the dignity of his son.
And is escorted out by Dallas police.
We believe in legal process, and that is where the truth will come out. To the family who experienced the loss, my heart truly goes out to you.
April 23rd, police confirm reports of threats, fake deliveries, fake calls for service at both Metcalf and Anthony homes. 2 days later, the FBI is looking into doxing claims. The judge who lowered the bond, her private information was illegally released online. June 9th, the school district won't release surveillance video from the incident, but allowed us to watch it at their district building. For the first time, a glimpse into the incident and the response. June 24th, a grand jury indicts Karmelo-Anthony on a murder charge. District Attorney Greg Willis says the death penalty was never on the table.
That would not be something that we could do even if we wanted to.
July 9th, Judge John Roach of the 296th District Court sets trial for 2026. July 24th, the court orders a subpoena of the school district and critical investigative information. The district sends letters home to families and students who may be witnesses to the event.
If you were to ask any superintendent in the state, that's probably their worst nightmare.
Days later, July 29th, the judge imposes a gag order for both sides. No one connected to the trial can speak on it publicly. September 5th of last year, Memorial takes the football field in honor of Austin Metcalf. His number 11 spells out all in. His father, under gag order, signs, "I love you," to his son. Early 2026 saw routine trial events, pre-trial motions, most out of public view. In April of this year, Judge Roach issues strict courtroom rules for trial: no cameras, limited seating, and heightened security. Which brings us to June 1st, the beginning of jury selection, the beginning of the real criminal trial that is much talked about and for many already decided in the court of public opinion. The scrutiny is as high as the stakes. Karmelo-Anthony faces life in prison. For two families, the timeline doesn't end here. In Collin County, I'm Jobin Panicker.
This is a tragedy that rocked North Texas and shattered two families that built their lives here. One student now facing life in prison, the other's life cut short. We spoke with Austin Metcalf's mother, father, and twin brother hours after he was killed to learn more about who he was.
They were inseparable brothers, even at birth. Identical twins born 4 minutes apart. Austin Metcalf was just a little older.
They had each other's back. They were tight. Those boys were my everything.
And everything changed on April 2nd, 2025, the day Austin Metcalf was stabbed and killed at a track meet in Frisco. An honor student in the classroom. On the field is where Austin really shined. Played every sport you could imagine.
His goal was to play in college. He just wanted to play football.
He would step on that field and he would become a totally different person.
Austin was a standout linebacker at Memorial, second team All-District honors. Last September, they ran out of the tunnel carrying his number 11.
Yeah, it's an emotional game, but man, our kids are resilient.
No one may feel Austin's absence like his twin brother, Hunter.
We did everything together. Clean the dishes together, do yard work together, sports, anything in the world, it's always us two.
They went to church youth group together, even worked at the same place. They were servers here at Halo Pizzeria in Frisco. In late May, Austin would have walked this stage to pick up his diploma. Instead,
Hunter Metcalf.
Hunter walked it in his honor. The standing ovation that followed lasted 30 seconds. In June, Hunter may have to take the stand in his brother's death.
I'm so worried about my son because he's going to have to face this world alone now.
The brothers who shared everything, classrooms, football fields, even work shifts, are now separated by a tragedy. In Frisco, I'm Jobin Panicker.
For many, the only image of Karmelo-Anthony is the one taken after he was charged with murder. But tonight, a look at the life he lived before the case that shook North Texas.
Many of you have seen this photo of Karmelo-Anthony at 17 years old, charged and booked for murder. But there are also these photos, the eldest of 4 Anthony children.
We wanted to give our children the future we did not have.
Through his family, we know they left Baton Rouge, Louisiana a few years ago, settled here in Frisco, where he attended Centennial High School.
Karmelo-Anthony, class of 2025, Centennial High School, Frisco, Texas.
He ran track, played football, and was captain of the team.
What's the number 1 seed?
His highlights showcasing that talent are still up online. We've learned Karmelo-Anthony worked 2 jobs, was an AB student before the April 2025 stabbing incident at a track meet. It would take him out of school and turn 2 families' lives upside down.
He's been raised in a 2-parent home with structure, stability, love, and we put God first in everything that we do.
Sources close to the family say Karmelo was able to graduate and receive his diploma, but he did not walk the stage or participate in any senior activities.
Explain your self-defense.
There hasn't been another public photo or video of Karmelo since he disappeared into this SUV and into house arrest. His bond conditions prevent it. Karmelo is now 18 years old, and the next time we see him is when he gets his day in court. In McKinney, I'm Jobin Panicker.
Legal experts say the final outcome in this case could ultimately come down not to guilt or innocence, but also to how a jury interprets the moments leading up to Austin Metcalf's death. Kevin Reese breaks down the possible paths this case could take and the wide range of punishment allowed under Texas law.
And I asked the grand jury to return a first-degree murder indictment against Karmelo-Anthony, which they did.
In charging the then 17-year-old with murder, the Collin County District Attorney alleges he did intentionally and knowingly cause the death of an individual, namely Austin Metcalf, by stabbing him with a knife a deadly weapon. If convicted, the sentence range, according to Texas law, is anywhere from 5 to 99 years in prison. And according to Texas law, someone under the age of 18 cannot receive the death penalty or be sentenced to life without parole.
Finally, let's remember that a defendant is presumed innocent unless and until proven guilty in a court of law.
Well, I think that there's a lot of things in this that we don't know yet.
Keith Harris is an attorney not connected to this case, and he explains that a murder charge could be reduced to a second-degree felony if the defense successfully proves the defendant acted under the immediate influence of sudden passion. That could mean a sentence range, if convicted, of 2 to 20 years.
Is used, usually not in the guilt innocence, it's more in the punishment phase of everything.
But there is first the argument over whether Anthony will be convicted or acquitted.
The truth will come out.
One family convinced.
There were too many people that were there that saw what happened.
The other.
We believe in legal process, and that is where the truth will come out.
Anthony's family and legal team alleging it was self-defense.
He's in an almost impossible situation. I mean, it's going to be very difficult. Even if he hired the best lawyers in the country, I mean, they would have their work cut out for them.
We are confident that when all the facts are presented and the full story is heard, the jury will reach the right conclusion and justice will be done.
Justice that could range anywhere from acquittal to 99 years. In Dallas, I'm Kevin Reese.
As you just heard, Karmelo-Anthony's legal team is arguing this was self-defense. We have spoken with many attorneys who say this is going to be hard to prove, especially if Austin Metcalf did not have a weapon. Senior crime and justice reporter Rebecca Lopez takes a closer look at how a self-defense argument could play out in court.
The defense strategy is already clear.
Self-defense is a protection that applies to each and every one of us.
Explain your self-defense.
Karmelo-Anthony's defense attorney Mike Howard asked the public to not rush to conclusions before hearing all the evidence surrounding the deadly confrontation between Karmelo-Anthony and Austin Metcalf.
This is a tragedy all the way around for both families. Rushing to judgment, trial by public perception and trial by media is not how we ensure justice is done.
Legal expert Keith Harris says the defense has to show why the jury should consider self-defense. According to the arrest affidavit, Metcalf was unarmed, while Anthony brought a knife to a track meet.
I think that that's ultimately going to be something that a jury also considers as to whether or not he even should have had it to begin with.
Police say the confrontation began when it was raining and Anthony sat under the tent where Metcalf and his team were sitting. Police say Metcalf asked Anthony to move from under the tent. Officer Taylor Wetzel wrote in an affidavit that a witness told him Anthony grabbed his bag, opened it, and warned Metcalf, "Touch me again and see what happens." Witnesses told police Metcalf then touched or grabbed Anthony while trying to move him, and Anthony allegedly pulled out a knife, stabbed Metcalf once in the chest. Metcalf's twin brother, Hunter, was standing next to him.
We asked him to move. He started getting aggressive and talking reckless. And my brother stepped in and said, "You need to move." He's like, "Make me move." Austin grabbed his backpack.
Harris says those facts could become critical for jurors.
The prosecution could say that he was kind of asking for it. I think the flip side for the defense, when you think about it, these are 17-year-old boys. And I was 17 at one point in time. And so you think about 17-year-old boys don't make the best decisions.
In an arrest affidavit, Officer Eduardo Cortez said, "As we were walking him, Anthony, to the squad car, the suspect was emotional and said, 'He put his hands on me. I told him not to.' Another officer later wrote, Anthony made another spontaneous statement and asked if what happened could be considered self-defense. Harris says those statements are important because they may help Anthony's attorneys get self-defense in front of a jury.
If the officers testify to what he told them as soon as they got there, that's going to be the scintilla of evidence that defense would need to get self-defense in the charge.
As a defense attorney, they're going to try every avenue. That's their job. The truth will come out.
Under Texas law, once self-defense is raised, prosecutors must disprove it beyond a reasonable doubt. Harris says the defense may argue Anthony reacted emotionally and impulsively in the heat of the moment.
We believe in the Constitution. We believe in the laws of this state. But those laws must apply to all of us. not just some of us.
Ultimately, jurors will have to decide whether Karmelo-Anthony was defending himself from danger or whether a verbal confrontation with an unarmed teenager should never have ended in deadly force. In Collin County, I'm Rebecca Lopez.
In July, months after the stabbing, Judge John Roach put in place a gag order, trying to maintain fairness ahead of this trial. The gag order blocks attorneys, law enforcement officers, witnesses, and even students who may have seen what happened from speaking publicly or posting online without court approval. Once the trial begins, we are expecting witness testimony from students, coaches, and first responders. That gag order has prevented us from speaking with people who were close to the incident. Jobin Panicker had the opportunity to watch surveillance footage from the track meet, and here's what he saw.
Our public information request with Frisco ISD was met on Monday. We could only watch the before and after of an April 2nd alleged stabbing at a school track meet that led to the death of one student and the arrest of another. The district didn't give it to us, but allowed us to watch it. The video is available for limited viewing only, citing student privacy and school security. There is no audio. Try to picture this. We're on the 4th floor. We walk into a room and there's a TV with a shot showing half of Kirkendall Stadium. It's a wide shot from the opposite side. And everything that happens in one very small fraction of the screen in the upper left-hand corner. We couldn't zoom in. It's blurry, pixelated. You cannot identify or see victim Austin Metcalf or suspect Karmelo-Anthony. It is hard to tell how many people are under that memorial tent. It's also hard to tell what they're doing. But we do know that about 9:55, there's a lot of commotion, a lot of activity that happens at the top side of that memorial tent all the way down to the bottom. At this point, it is hard to tell, and it does not show on camera the alleged stabbing. We do know that there are a lot of people that run away from that scene soon after. We notice a number of what appear to be students running across the bleachers from many directions away from the tent. More people on the field start to notice and also run toward the back gate and exit. Okay, at about 9 minutes after the alleged stabbing, we see EMS drive right through to the backside of this stadium, and they park midfield. Next, we notice paramedics wheeling out a gurney, but have to walk all the way back to the gate and to the bleachers. There's a lot of activity at the bottom of those bleachers and what appears to be the triage of Austin Metcalf. 15 minutes after the incident, we see people put the tarp over the bleachers, which our helicopter cameras captured. All right, so looking at the timing, there's 26 minutes between the time of the alleged stabbing and the time EMS leaves Kirkendall Stadium with Austin Metcalf. At the same time, what appear to be officers, they are at the crime scene right next to that tent. All of this video will one day be shown in court. A grand jury may see it too in the coming weeks. The attorney for Karmelo-Anthony confirms he's seen it, but neither family has disclosed whether they've seen it. In Collin County, I'm Jobin Panicker.
This incident started as a case between two teenagers, but has since turned into a nationally debated and deeply divisive story. With cameras not allowed in the courtroom, our team is preparing for detailed coverage of this trial. Here's Tiffany Liu.
On April 2nd, 2025, 17-year-old Austin Metcalf was stabbed during a track meet at Frisco ISD's Kirkendall Stadium.
I drove up to the hospital and straight away. I actually beat the ambulance there.
Police say another 17-year-old student, Karmelo-Anthony, stabbed Metcalf under a team tent during a weather delay.
He was on a lot of machines, and it didn't take long for them to come in to say that he had passed.
Anthony was arrested at the scene.
I got the alleged suspect in handcuffs right now, detained.
He was later indicted on a murder charge and has pleaded not guilty, claiming self-defense.
We believe in legal process, and that is where the truth will come out.
Two families are forever changed in very different ways. And in the days after the stabbing, both mothers spoke publicly.
My son is not here anymore, and I don't understand it.
One mourning her child's death.
He's just such a good spirit, and so many kids loved him, and his brother's lost his best friend.
The other defending her son accused of causing it.
I don't know why we are being targeted and discriminated against before a fair trial. Our son deserves the same rights under the law that everyone is afforded to.
Outside their grief, what happened at a high school track meet in Frisco became something far bigger than this community. The case spread across social media, drawing national, even international attention. Online debates over self-defense, justice, and race intensified. The families and the judges connected had their personal information leaked and received death threats. So as the trial approaches in Collin County, security will be higher than normal. Cameras generally aren't allowed in this courthouse, and that rule applies for this case too. It's why our team of journalists at WFAA will monitor the trial closely. Collin County reporter Jobin Panicker will be our eyes and ears inside, documenting the testimony and evidence as it happens alongside a sketch artist. Outside the courtroom, senior crime and justice reporter Rebecca Lopez will follow the developments as the case unfolds. On WFAA.com, we'll keep a live blog updated. Then each day after adjournment, anchor Jason Wheeler and senior investigative reporter Tanya Iser, along with a team of legal experts, will stream a full after the trial recap. All of it available on WFAA+. Karmelo-Anthony's trial for the death of Austin Metcalf will be a challenge as public opinion has been shaped far beyond courtroom walls. It'll face intense scrutiny in what could be one of the most closely watched trials this year in North Texas.
The questions surrounding this case are far from over. Throughout the trial, WFAA is your place for complete coverage on air, online, across social media, and streaming on WFAA+. You can depend on us to keep you apprised of developments inside and outside the courtroom. Thanks for watching.